Dictation starting 5 seconds. Start. The question is as to whether the interference with the punishment by the labor court was justified or not. In other words, the question is whether the punishment imposed was so harsh or so disproportionate to the charge proved that it warranted or justified interference by the labor court. Here, it had been clearly found that the employee during work had hit his superior officer with a tension screw on his back and on his nose, leaving him with a bleeding and broken nose. It has also been found that this incident was followed by the unauthorized absence of the employee. It is in the context of these charges found established that the punishment of termination was imposed on the employee. The jurisdiction under section 107A of the Act to interfere with punishment when it is a discharge or dismissal can be exercised by the labor court only when it is satisfied that the discharge or dismissal is not justified. Similarly, the High Court gets jurisdiction to interfere with the punishment in exercise of its jurisdiction under Article 226 of the Constitution of India only when it finds that the punishment imposed is shockingly disproportionate to the charge proved. This court, after referring to the scope of interference with punishment under section 11A of the Industrial Disputes Act, held that the labor court was not justified in interfering with the order of removal from service when the charge against the employee stood proved. It was also held that the jurisdiction vested with the labor court to interfere with punishment was not to be exercised capriciously and arbitrarily. It was necessary in a case where the labor court finds the charge proved for a conclusion to be arrived at that the punishment was shockingly disproportionate to the nature of the charge found proved before it could interfere to reduce the punishment. This court, after referring to the decision in State of Rajasthan versus B.K. Meena 1996 6 SCC 417, also pointed out the difference between the approaches to be made in a criminal proceeding and a disciplinary proceedings. This court also pointed out that when charges proved were grave vis-a-vis the establishment, interference with punishment of dismissal could not be justified. This court again reiterated that the jurisdiction to interfere with the punishment should be exercised only when the punishment is shockingly disproportionate and that each case had to be decided on its facts. This court also indicated that the labor court or the industrial tribunal, in terms of the provisions of the act had to act within the four corners thereof. It could not sit in appeal over the decision of the employer unless there existed a statutory provision in that behalf. The tribunal or the labor court could not interfere with the quantum of punishment based on irrational or extraneous factors, and certainly not on what it considers a compassionate ground. It is not necessary to multiply authorities on this question since the matter has been dealt with in detail in a recent decision of this court. Done.